Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're going to be talking about divorce. But before we get started, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. What is a divorce? A divorce is where a marriage is brought to an end by the courts. When people get married, they cannot go to the court to get divorced before a period of 2 years comes to an end. So if you get married today, you have to wait for 2 years to finish first before you can even go to the courts to ask for a divorce. In order for a person to bring a divorce before these 2 years come to an end, they have to actually apply to the court and give the court good reasons why they should be allowed to apply for the divorce before the 2 years finishes. And these are where, 1, the person who is asking for a divorce is suffering undue hardship from the person who they want a divorce from. Or the person who they want a divorce from is acting in an absolutely depraved manner. There is only one ground for divorce in Botswana, and this ground is irretrievable breakdown of the marriage. Irretrievable breakdown of a marriage can be shown in 4 ways. And these ways you can show together in your court papers for divorce, or you can just show one, or whichever combination. The first ground is that there has been adultery, and that the adultery has caused the plaintiff, being the person who is bringing the divorce, to be unable to live with the defendant. So it's not just simply the fact that there is adultery. The adultery must lead the plaintiff not to be able to live with the defendant anymore. The other ground is unreasonable behavior on the part of the defendant. And this unreasonable behavior can be any number of things, as long as it is of such a nature that the plaintiff can no longer tolerate to live with the defendant. This can be where the defendant beats the plaintiff. This can be where the defendant mistreats the plaintiff badly and the plaintiff is saying, I cannot do this anymore. This could be instances where they live together and the defendant does not contribute anything to the household. Everything is at the doorstep of the plaintiff, even though the defendant has a full, well-paying job. The defendant is hardly at home. It could be any number of reasons. As long as you can show that the behavior is unreasonable and that the plaintiff cannot tolerate this behavior anymore. The other one could be desertion. When a party is alleging desertion, the person should have been deserted for a period of 2 years or more. Where a person just leaves home and they don't say where they're going, they're no longer involved with the home. Even when you know where the person is, when you go to them, they act as if, you know what, they want nothing at all to do with this marriage. So in that situation, the plaintiff can bring the divorce action and say, the defendant has deserted me and therefore I believe our marriage has irretrievably broken down. And one final one that can be shown is where the parties agree that they have been living apart for a period of 2 years or more. And in this instance, the plaintiff in bringing the divorce action would have talked to the defendant, and once the summons has been issued and the plaintiff has said we've been living apart for 2 years, the defendant will sign the necessary consent in order for the divorce to be given. And you will note from this that of these 4 ways of proving irretrievable breakdown, 3 require the plaintiff to actually show that there was some wrongdoing on the part of the defendant. This means that if you are the one at fault, let's say you are the one committing adultery, you cannot run to the court and say, I want a divorce because I've been committing adultery. The person who brings the divorce action should be the one who is saying this person has done something that has caused our marriage to irretrievably break down. And the reason why I keep emphasizing irretrievably is because not only do you have to show that there's a breakdown in the marriage, but you have to show that there is nothing that can actually revive this marriage. That is why it's called irretrievable breakdown. Once the parties have gone to court and they've satisfied the court of this irretrievable breakdown of marriage, the court will then give them what is called a decree nisi for divorce. The divorce, it's not absolutely finalized until a person has been given what is called a decree absolute. And a person can only apply to be given a decree absolute after 6 weeks from the decree nisi being granted has passed. So if you've been granted your decree nisi today, the divorce is not complete until you get your decree absolute, and you can only apply for the decree absolute after 6 weeks has passed from when you were given your decree nisi. This means that technically, until the decree absolute has been given, you are not divorced. The 6 weeks is given as a cooling off period in order for the parties to go back, and if they within those 6 weeks decide, you know what, we can actually make this work, they can go back to the court and make the necessary application to have the decree nisi set aside. But if a decree absolute has been granted, the parties would not be able to go back to the court to have the order set aside. What they would in fact be able to do is to remarry each other. And while they only have a decree nisi, they cannot marry other people either. They would only be able to marry other people once they have been given their decree absolute. Thank you for joining me. I hope this was an informative discussion. Please make sure you like, you share, you subscribe, ring the notification bell so that every time I put up a video, you are notified. Make sure to follow me on my Facebook page, Botswana Thinking Law, and on Twitter at BW Thinking Law. And I hope to see you in my next video. Bye!